Hi, welcome to Southern Caregiver Resource Center's monthly live stream. I'm Marta Rañón, Executive Vice President of this wonderful organization, and it gives me great pleasure to welcome you today. If you are not familiar with our organization, Southern Caregiver Resource Center focuses on those individuals caring for the well-being of others who are frail, elderly, perhaps they have some sort of cognitive deficiency like Alzheimer's, dementia, or memory loss. And if you have not already connected with us, I encourage you to visit our website at www.caregivercenter.org or call us directly at 858-268-4432. It is on your screen. And of course, feel free to bring something to write with and a notebook so that you can take notes and jot down all of this pertinent information that I'm sure hoping you will find beneficial. Um, Today's topic is a topic that I think a lot of caregivers are interested in. You know, we're just coming out of the holidays, and a lot of individuals have been visiting family members and friends and loved ones and are noticing that there are a lot of changes and maybe perhaps more assistance that is needed. When caregivers find themselves in that situation, they often have questions, which is why today we are going to be focusing on those very specific questions that have to do with finances. In this particular case, it's Medi-Cal changes that are taking place now and the impact that these changes will have on family caregivers. Our presenter today is Kimberly McGee. She is a certified specialist in estate planning, trust and probate law by the State Bar of California Board of Specialization. She's a certified elder law attorney and by the National Elder Law Foundation and a VA certified accredited attorney. She focuses her practice in the areas of estate planning, trust administration, elder law probate, conservatorships, long-term care planning, and asset protection, and also takes an active role in the dementia and elder care community, providing support to local community organizations. Kim, it is such a pleasure to have you here. Welcome.
Thank you for having me.
I know this is a topic that a lot of caregivers are interested in. I know you have a lot of information for us today. There are a lot of changes that are happening to laws that pertain to Medi-Cal. So you have the floor to feel free to jump right in. So I know we have a lot to cover today. Thank you so much for being here.
Thank you so much for having me. And yes, we do have a lot to cover, and I'm going to do my best to kind of break it down and help everyone understand how it applies to you, because there have been some major extreme changes on January 1st of this year. And what makes it difficult is that these changes only apply to California. So a lot of the times we get a lot of our information, and the information we get is nationwide, right? There's nationwide banking, there's nationwide insurances, there's nationwide organizations that provide the information that's applicable to 49 other states. And so this is it's hard information to kind of delve through, and there's not a lot of it being produced only because it is only applicable to California. So what I'd like to do is we're going to start with kind of walking through some definitions, because it's a complicated topic, but not really if we take some of the definitions away, right? So we're going to start with distinguishing between Medi-Cal, Medicaid, and Medicare. A lot of clients will come in to see me and they'll say, well, when my loved one gets sick or when I get sick, Medicare is going to cover it. And I say, well, no. Medicare is an insurance program. It was like Blue Cross Blue Shield. It was, Anthem. It's just insurance. It's Kaiser. It's simply just insurance. So it's your health insurance. So Medicare generally is going to be your hospital. So who pays for your hospital? Medicare is going to be a medical insurance. Medicare is going to be either your Advantage plan. So let's say some people, when they decided for Medicare, rather than getting a supplemental insurance to go with their Medicare, they got an Advantage plan. So Kaiser, and I think Sharp may have one now. And then there's also Part D, which is your prescription drugs. That is just your Medicare, just basic insurance, doctor visits, hospitals, and pharmacy. But then we move on to Medi-Cal. Now, this is where it gets confusing. Medi-Cal is just Medicaid, but we're California and we like to be special here. So we call it Medi-Cal. And it really is more important than ever as of January 1st because our rules were always a little different than the other 49 states, but now they're extremely different. So Medi-Cal is a version of Medicaid, but it doesn't look like Medicaid anymore. But it really is, it's a combined program. It's a federal and state. So that's where the money comes from. But it's insurance, but it's also a lot more. And that's where people kind of start to get confused with their Medicare, Medi-Cal. You can be Medi-Medi, which is I have Medicare, and I also have Medi-Cal. So Medicare covers my 80%, Medi-Cal covers the other 20%. So next slide, please. So I kind of walked through where you can be both. And so then you can qualify in different ways for these programs. And one of a really common way that people qualify for Medi-Cal is through SSI. And if a loved one is receiving SSI, you know they're receiving SSI because there's very strict rules. Next slide, please. Sorry. There's some very strict rules. So the person must be age 65 or older, blind, or disabled. And then they will then get about $943 a month from the federal government. And then California has an additional bonus that they give. But that you get because you can only have $2,000 in your name. That was a really common way that people got Medi-Cal. Medi-Cal has changed dramatically. And that's why I'm pointing it out because there's a major change now. Pretty much most people are going to have a way to qualify for Medi-Cal based on their income. And we're going to talk about it. So the different types of Medi-Cal. There is the ACA Medical Expansion. That's the Obamacare type. And that is where it's just the health insurance. So there's no asset limits. There's no disability requirements. A lot of people got that under Covered California. You also then have the aged and disabled federal poverty level program. That is where you can get all the Medi-Cal services for people who are aged, meaning aged means anybody over 65. I disagree that is aged, by the way. I've got some clients they're like 79 years old and they're in better shape than most 25-year-olds I know. So don't be, offended by their language, but aged means over 65. I always laugh because in the VA, they just recently changed the rules in their regulations. They actually called you disabled if you were over the age of 65. They changed that about 4 years ago, but it always made me chuckle. So you can either be disabled or over 65, but your income eligibility is always going to be limited. And so in 2024, if you make under $1,676, you are qualified for Medi-Cal. And that's for the aged and disabled. If you're talking about the medically needy, this is also people who have full-scale Medi-Cal. And I've seen this in situations where people go in and they have such major medical concerns and there's no way they could afford them. And that Medi-Cal will come in and protect them from that. So you will have a copayment based on your ability to pay, but it's going to lower everything. So that's that's like the health insurance side of Medi-Cal. There is, more importantly, and I'm hoping that this is what you take away from it, is Medi-Cal is just not health insurance. It is community-based programs. It is programs to enhance quality of life, right? I've had people, my mother included, consider Medi-Cal like a dirty word, like there's something wrong with it. And I want people to understand that it was created, number one, to end the pauperization of spouses. And that was how it was created. Ultimately, that's in the original legislation. It was really to protect spouses from a catastrophic injury when one spouse got injured. And now we've been able to expand it to increase the quality of life to people who get sick or injured or disabled. And it is something that should be celebrated and not something that you should consider anything wrong with. But the home and community-based services, these are the things that get you out of nursing homes, right? We have a public policy in California. We don't want people in nursing homes. Nobody. I mean, you don't even like to go visit your loved one in a nursing home, let alone live in a nursing home. It is a place that they're needed and they're necessary, but nobody wants to live in a hospital-like setting. And so they are options for getting people out. So I just want you to know they exist. The assisted living waiver program, that is probably the one that you should focus on. So if you have a pen and paper, make sure to write this assisted living waiver program down. What it is it's to keep people out of nursing homes and to keep people in the community. And the community means in assisted livings, right? They're either the, like, cruise ships on land. They don't like when we call them that, but the apartments that have the restaurant and the care built in. And then you have little board and cares where you can have a converted home, those kind of things. And it also includes some memory care. So you've got the smaller assisted livings that have the locked doors. Those would be part of the assisted living waiver program. So people need to realize that there is help. There are options. A lot of times we have to navigate it and there are long wait lists, but the wait lists are manageable if we kind of start some pre-planning. We can't wait till the last second because nobody wants to acknowledge the problems. And so when we're family caregiving, right, we're giving our all, we have to acknowledge that there could come a point where I can't do it. And not only is that a good thing to acknowledge, because you're going to create the best quality of care for your loved one when you acknowledge your limitations and you acknowledge that there will come a time, and we plan for it so you can plan for the best. So we look at the Medi-Cal options. And so when you're looking at the eligibility, I put it here just so you know, and these rules keep changing a little. So be mindful that when you need it, it might be a little different. But basically, if you can qualify for Medi-Cal and you do need a nursing level care, meaning I need assistance with, 2 activities of daily living, and then you can do it. Statewide, if you're watching, just know that it only is applicable to certain counties here in California, and San Diego County is one of them. There's also what everybody watching should really be always considering as an option is in-home services, right? So there's in-home operations, in-home supportive services. Next slide, please. Oh, there, you're ahead of me. We call it IHSS. So you'll hear IHSS. I just want you to be familiar with the term because you will hear it at the hospital. Are you getting IHSS? And that is where a family member can be paid as a caregiver. And you can either get a caregiver through the IHSS program, you can hire one privately, or you as a family member, spouses can't get paid, but you as a family member could be getting paid for the work that you're doing. And it's not just for the nursing level, the custodial care, it's also dressing, it's house cleaning, shopping. I always found that one really beneficial because mom may be a wanderer and I can't get to the grocery store, or I can't even go upstairs and clean the bathrooms because mom will elope. Those kind of things that happens. And so if that's the support you need, maybe IHSS can help you with that. But it also does the heavy caregiving, the bathing, the dressing, the feeding, that kind of thing. But it's a great option. So to be eligible, you really just have to fall within the Medi-Cal eligibility. Again, if you're receiving SSI, you're automatic. And now we're looking at, and we're going to get to those slides about the major changes that have happened, that it truly is going to be income-based. We also have other Medi-Cal services that you really should be looking in on. And those are like case management and home health aides services. So additional, sometimes we as the caregiver could benefit from just a little break, right? We're still okay. We can do all of this, but we really need a little break. Maybe somebody coming in a few times for an hour or two once in a while is really what we need. Sometimes we need more. I've seen these programs used to modify the home. I've had doors widened so that wheelchairs can go through. I've had showers fixed so that we can wheel the wheelchair in there. Respite care. And I mean, if you're watching this, you probably know what respite is, but I'd like to make that joke that if you don't know what respite is, you need it. But that is something that, SCRC can definitely help you with. But Medi-Cal offers it too. So you've got Southern Caregiver Resource Center providing help. You've got Medi-Cal providing help. All of a sudden, a burned out family caregiver might not be so burned out. And these are why it's so important to know what's available and how we can qualify for them. There is the MultiPurpose Senior Service programs, and these are, the PACE programs, the ones that we hear about. All county is covered by them. There's a lot of options there. My favorite one that's offered through there is the adult daycare option. I think I have families that utilize that one the most. You can still go to work if you're working, because you can, sometimes, if you're in a certain area, the bus will pick you up or pick your loved one up, take you there, bring them back, all of those things. So they can kind of make it possible to do this and care for them and keep them out of facilities, because a lot of times we don't want to be in facilities. But you got to realize there's a lot of things. I see translation and interpretation as one of a greater aspect that they can provide, because sometimes it's the lack of communication that causes the lack of awareness and knowledge for certain services. And again, transportation, I find that really a big one. Especially if we've got somebody who's wheelchair bound and we can get them a van to come in and out, to take them to doctor's appointments and to social activities. Because let's not forget, social activities is what keeps us from declining in general. It slows our mental decline when we're stimulated. We all realized that during COVID, that the more isolated you are, the faster your mental cognition will decline. And it happened with everybody, whether they had a diagnosis or not. So Medi-Cal also, what most people think of is the skilled nursing, right? A lot of people think of skilled nursing, which is a very, very big part of Medi-Cal, and something that we really want to consider always, because there is custodial care for the long term. So Medicare will not cover skilled nursing over 100 days. It actually will only cover, Medicare only covers 1 to 20 days at 100%, and then 21 to 100 days at 80%. And you have to cover the difference. And it's usually with your supplemental with a copay of $150 a day. That's fairly expensive. And so that is why Medi-Cal is great, because if a facility accepts Medi-Cal, every bed is a Medi-Cal bed. So when you hear, oh, we have no Medi-Cal beds, if they accept Medi-Cal, that bed that they're in is a Medi-Cal bed. It can include rehabilitative services. That is an option. They always say it's not, only because a lot of facilities don't know, right? They can ask for it. You just have to apply through the Medi-Cal program themselves, and they might not be educated on it either. So now you know. And you are going to have an indefinite stay, and it just depends. Your share of cost is then based on what your income is, right? So if I have an income of, I'm going to try to do math easy for me, $3,035 a month, and I'm not married, then my share of cost in that skilled nursing facility will be $3,000, because I get to keep $35 a month for a haircut. It's called I just make that up, but the $35 is your personal needs allowance. So you get to keep that from your income. We're going to walk through what happens if you're married, because that is a really large benefit. Because remember, Medi-Cal was created to end the pauperization of spouses. So we in California had major changes. This is the purpose of this presentation. And there was something called SB 133, and that was in the legislation in the 2021 session. What it did is it eliminated the asset cap for eligibility. This is why I said everything you may Google on Medi-Cal may be wrong, because you're going to hear about Medicaid in 49 other states. And in 49 other states, the asset limits for Medi-Cal or Medicaid are $2,000. In California, in July 1st of 2022, we increased that $2,000 up to $130,000. And the community spouse resource allowance, which I did not update for this slide, I apologize. It's for 2023 was $148,620. So for a time, you could have, what is that? I'm trying to do math in my head, $278,620 and qualify for Medi-Cal. But effective we're 16 days ago, the asset limits for non-Magi Medi-Cal, which means for the basic, what we're talking about, the aged and disabled, is gone, meaning completely gone. So the CSRA, the Community Spouse Resource Allowance, is irrelevant. At this point, what does that mean? That means that I can have $800,000 in the bank, investments, IRAs. I can have a house. You could always have had a house. So you all of a sudden have these assets that now don't count. This is a very, very big change. You know, a lot of my clients were always just a little over, or, you know, they did what they were supposed to do, what they were told to do, save, save, save. And then by saving, they said, okay, well, now you have to spend $15,000 a month for care. Well, that's only going to last so long. And then what's my spouse going to do? And then and I saved all this because I wanted to give my children a better life. And I told them not to, you don't have to work there. Why don't you do this instead? Because I'm going to leave all of this to you, whatever it might be. It impacted, right? Now it doesn't. So when you look at post January 1st, 2024, all we care about now is income, meaning your assets are irrelevant. I make the joke only because I don't know if it's true or not, but I read something that, Bill Gates doesn't pay income tax or something like that. And if that was true, because, then somebody who's wealthy like that and doesn't pay income tax would qualify for Medi-Cal. You can have $1 billion in assets as long as you show no income or low income, you'd still qualify for Medi-Cal. So I think that's a good, example. It's not true example, but it's a good example of what we're looking at now. And so I had said the previous slide, if you are a single person, it is $1,676. Is that what I said? For your income. That is your income cap. That is the amount of money that you can have and qualify for Medi-Cal. Medi-Cal, when we look at like actual income is your net income. So let's say that I get $2,100 a month in Social Security. I'm over that $1,676 threshold, right? Yes, I am. But I pay $350 a month for a supplemental. I have, how much is Medicare? I don't remember what Medicare went up to. So I have my Medicare, let's say $200 comes out from Medicare. Oh, wait, all of a sudden, I just got down to the 1676 number. So what the income limit is that your gross income minus all of your health insurance. That's your medical, dental, and vision. So, there are some people that end up just buying a vision plan and qualify for Medi-Cal. And so, because that's the math you have to do. But if you're married, this math becomes a lot different. And there is something called, and I have a typo, it's supposed to be minimum monthly maintenance needs allowance. And it's the MIMNA is what we call it. But it's the amount of income that's determined by each state under the federal guidelines. Of course, remember, this is a state and federal program that is needed by the well spouse, meaning the non-sick spouse. So I'm going to use the example of the husband getting sick because that, and the wife being the well one, usually taking care of her husband. That is just because it's the most common one I see. The wife's, one spouse gets sick, the other spouse is not. So the well spouse is the one at home. And the sick spouse is the one at the hospital or moving to the facility. And in order to stay residing in the community, California has said that well spouse needs $3,854. So how does that work? I've got a couple, right? Spouse one makes $2,500 plus some sort of $64 railroad pension. I can't believe how many railroad pensions I see, but I really do. And they're like $64. But we've got some, miscellaneous Social Security. We've got miscellaneous pensions. We've got all these other things for one spouse. And then the other spouse, generally there was a non-wage earning spouse, right? Because the two income households are a fairly, societal new idea when it comes to this age range, right? So there's usually one with the high wage earner that has the higher Social Security and some pensions. And then we have the lesser wage, the homemaker who had lesser wages has about $800. So we're allowed to shift that money over from the sick spouse to the well spouse. And that is what we're going to start doing. And so you have the MIMNA, which is $3,854. All of that money, if that's the amount that goes over to the well spouse, you're fine. You qualify. So as a couple, if your assets are below $3,854, one of the spouses can now qualify for Medi-Cal, regardless of your assets. You can have IRAs, you can have investment accounts, you can have even a rental property. However, does that rental property create income, right? We're going to start looking at sources of income. And that now becomes the new thing. I can have a second home. I just can't be making money off of it unless it's going to kick me out. And so what we look at as planners, so you've got the lawyers kind of sitting back and trying to figure out, what are we going to do with all of this? How do we shift it? How do we get the sick spouse healthy or financially in a place to qualify for this? Because again, remember what we're trying to do. We're trying to protect the well spouse. We're trying to not let the disability, the illness of one spouse impoverish the other spouse. And that's where this became a big deal. And what we're looking at as planners, and we're still working through this because these are brand new rules, and we're still looking towards Medi-Cal for more guidance. But we have something called name on the check rule. And I want people to think about this. Where the Medi-Cal considers income belonging to the spouse who gets it, right? It's a little different than the family law world, right? In a family law world, we're a community property state. All the money belongs to both, 50-50 equally. If there was, obviously, if it was earned during marriage, things like that. But Medi-Cal doesn't think of it that way. They look at the name on the check. And so I've told a lot of people that they've got, a husband and a wife or, two spouses. They have a joint investment account, and it kicks off dividends, or, they have some sort of joint other type of account that's income producing. If we take off the well or the sick spouse off that account, where is the check now going to come? That's the kind of thing I want you to think about. Regardless of the amount, the community spouse can keep what they want. Whatever's left in the name of the sick spouse is just the share of cost. And so what is share of cost? I don't think I explained that prior. But share of cost is Medi-Cal's version of a copay. And that's all. Think about it that way, right? If you've got a Kaiser or an Anthem or a Blue Cross or whatever your health insurance is, you have a copay when you see the doctor. It could be $5, it could be $25, it could be, $150 depending on your plan. But it's the same every time. And for everybody on that plan. Medi-Cal is different. Medi-Cal calculates that share of cost based on your income. So let's say we have two spouses and there's $5,800 of income. If we can transfer as much as we can over to the well spouse, you can't transfer some things, like you can't transfer, Social Security, things like that. So let's say they're stuck with $1,800 in Social Security. That $1,800 will be part of the share of cost, provided we've already hit the MIMNA. And I'm using that because I should have picked better numbers. Let's say there's $10,000 in income and 8 of it can be shifted over to the well spouse. Now you're well over that MIMNA number of $3,800, remember. And now you're below it. That $2,000 is what the share of cost is going to be, not the $10,000. And so you can now benefit from all of these services that I just went through, right? There's in-home supportive services, assisted living waiver programs, things like that. The assisted living waiver program, we may have to get them down a little more, but we may have to buy some extra health insurance. But that's the idea, is we want to start looking at how we do this. If you end up in a skilled nursing facility, that's another thing. How can we shift some of the income off? We're also looking towards, if you can't just turn it off by calling the bank, there's something called a 3100 petition, and that is the probate code that's being referenced. What you would need to do is you would have to call a lawyer, because and not very many do this. My office is one of them. The list that Southern Caregiver Resource Center has, a lot of those attorneys would be able to, but not a lot, because it is a very unique petition. But it's basically a petition saying, Judge, because my spouse got sick, I can't live on what I have. If all that money goes to the facility, I can't live. I can't buy groceries. I can't pay my electric bill. I can't do any of it. And a judge can then take all of the income and attribute it to the well spouse. So that is a really, really good option that's available for people. One of the bigger things that people have that I've noticed is they have these big IRAs. And by big, and big could mean one thing to everybody. But IRAs across the board have required minimum distributions. Those are amounts that have to be withdrawn, which is now income, right? The value is irrelevant, but the income that it kicks off is still relevant. So there's something called quadros. It's the Qualified Domestic Relations Order for Support. Now, I'm not a family law attorney, and those of you who have been through a divorce, this is probably giving you some bad flashbacks. But these are options that you don't have to divorce, but you can get these orders. So we, as planners on this, are working with some family law attorneys to kind of come up with the best system. But we have been told and learned from the family law attorneys, there's no divorce needed in order to get this. So we can assign the earnings for support over to the well spouse. That is something I'd really like people to remember, that they're not stuck when they say, oh, you don't qualify. You might. And when a little bit of effort to have a long-term support need, it's worth it. So one of the things that we're looking at right now is the rules haven't been really fully fleshed out on transfer rules. So in the past, right, your people who talk to me about Medi-Cal, they say, well, there's a 5-year look back period for making transfers. Number one, that's never been California's rule. That, when I said earlier that if you Google stuff for Medi-Cal, you will get information that applies to 49 other states and not California. And one of those was that 5-year look back period. That never existed here in California. We adopted that rule back in 2008, but we never implemented it. So we were still allowed to do transfers if they were done properly. So now that there's no asset cap, we still have some questions remaining on transferring or gifting, right? So if you do make a transfer and you don't, if it wasn't qualified, it would have made somebody ineligible. There is currently a 30-month look back, but transfers of exempt assets are not penalized. So the thought is any transfer would be fine because there's no penalty. And so what if that asset, it's not going to hurt you anymore, but the income is going to hurt you. So maybe we want to plan transferring assets that create income. And there's a huge thing. Do not do this on your own, please. And do not do this without consulting with the proper tax advisor, not even the lawyer, because I've seen lawyers not consider the tax implications. And I'm going to give this warning only because it comes through my door too many times by qualified attorneys who didn't think about taxes, because nobody likes to think about taxes anyway, right? But if you have an asset, let's say, I mean, this happens a lot, right? Mom and dad have a house, and they have the house next door as a rental. I see that a lot. Or maybe it's like a duplex. They own one half and they rent the other half. And they think, well, we're just going to transfer the half away because the income, right? We don't want to have the income. We want to qualify for Medi-Cal. Be very careful, because what could have happened there is mom and dad may have bought that property when it was worth $30,000. And that property now is worth $1,030,000. And if you transfer that, you transfer it at the capital gain basis of $30,000. Meaning if you go to sell it, you'd have to pay taxes on $1 million. If mom or dad owned that property when they died, that $1 million tax potential disappears. And so and I'm giving you this, I'm not going to talk taxes because everybody's eyes just glazed over. I saw you through it. I know, mine did too. But I'm giving you I want the warning. I want $1 million tax potential, right? To be a warning when you're thinking about transfers, which means any type of Medi-Cal planning you do needs to be done in conjunction with a CPA. It could be a quick phone call or it could be a full couple meetings, but it's just important. I don't want anybody to jump into something because they're so worried because my loved one is really, really ill. I can't afford this. How am I going to do this? This is an option. 1 month of paying an exorbitant bill while we get the plan right is so much better than rushing and making a bigger mistake. So that's why we want to take our time. We want to take a breath. So because transfers become such a big issue, it's important that we kind of talk about how we do it. And so the remainder of of our conversation here is going to be about planning. And the reason why is because I just gave you, there's all of these potential options out there, a lot, quite a few. And a lot of them are going to enhance you and your loved one's life. I want you to access them. Medi-Cal wants you to access them. That's why we have these rules. These rules are written to be accessible. Unfortunately, a lot of them you need when it's too late for the person who needs it to actively take a role, right? And so what do I mean by that? Mom, let's say you're caregiving for mom. And mom, she gets $1,500 in Social Security and she rents out an ADU on her property. So, that's some rent or, things like that. Or she has an annuity or something where she gets additional funds from. But we need to transfer it away. Well, by the time mom needs the care, maybe her dementia is so far that she can't participate in the decision making. So there's powers of attorney language that you can make sure is added to your transfer or to your power of attorney that allows for transfers. Now, if you have just the basic power of attorney, California has a statutory form, which is great for doing the basics, going to the bank, talking to SDG&E, canceling Cox, whatever it may be. That is a great one for the basics. But if we want to start doing planning, I want you to consider having that reviewed by an attorney who does long-term care planning, right? We want to make sure, and you can ask the attorney, does my power of attorney allow for transfers? And because in theory you can't, right? Well, what is a power of attorney? A power of attorney is when I give the power to a third person to step into my shoes. You can do my job for me. Meaning you can talk to people on my behalf, you can enter into contracts on my behalf, you can sign the admission forms to get into a facility on my behalf. But what you can't do is you can't take my money away from me. You can't use my money to pay your bills, those kind of things. So if your power of attorney doesn't specifically say you're allowed to do X, Y, or Z, specifically, you are allowed to transfer my rental property to someone else. That would be called stealing unless your power of attorney allows it. Now, I don't want you just to add it in there because you want to put limitations. It has to be for the limited purposes of helping me qualify for long-term care. There needs to be some guardrails put on there. And so that's a power of attorney is a big option out there. We can also convert income producing assets to non-income producing assets. Now I'm going to be presenting to some financial planners soon, and my plan there, because I'm not a financial planner, and I will not pretend to be one. But the idea is we need to figure out what that looks like. What vehicles are available? So I know that a really good one is, let's say I have this investment, some sort of investment that is kicking out a really, pretty good income, and it's pushing me over the threshold. Well, I know that there are like insurance options that maybe I can convert it into something like that, especially if you still have a well spouse. That's a great option. There's a lot of different potentials that are good investment structures where the money is still safe, it's protected, you can touch it, you can use it, but it's no longer kicking out an income. And so that's why this is a team effort, right? Caregiving, I know is very isolating. Especially, we're getting better now with the sandwich generation. I know, I've lost my parents. I get it. And now that it's becoming more commonplace for people to have kids and to have aging parents and trying to manage it all, it's not, it's not as isolating, but it truly is, right? And you forget that you don't have to do it all on your own. And there's a team, and you got to build that team, and you got to find that team. And so finding planners that can help you get creative, because some of these diseases are very long term, right? Some of them are not, but you're here for support because you are caregiving for somebody that has most likely a long term, and it is exhausting, and I know it. So let's get the team going. One of the things I've been really exploring is spending down our IRA and retirement accounts first. And I say that why? That's like the antithesis. It's like the anti everything we've ever learned. We save that money, we save that money, we save that money. But we don't now, because that money is what's going to pull us down. Because why? What happens with your IRA and other retirement accounts? They kick out income, required minimum distributions. They're required. You don't get a choice. And so we want to start spending those down. Now, remember, warning, taxes. I hate taxes. You hate taxes. Everybody hates taxes. But we want to spend it down in conjunction with our CPA, right? We can, if we are now receiving care, and so you're supporting your loved one, and then you're paying for some supportive care, talk to the CPA. Paying a caregiver can be a tax write-off. You can take from an IRA that's income taxed. You might be able to offset some of your income tax with your caregiving. You can strategically decide how much caregiving you want to pay for and take out from your IRA such that they balance each other out. This could be a really, really good plan. And now you're taking the money out of the asset that can create the most problem. I hope that makes sense, because that is something that I really want people to understand. We have been drilled into us. Do not touch the IRA. And I want to tell you, because of on January 22nd of 2019, the federal government passed the Secure Act. And I have to memorize what it says, but it's something that makes it really good that everybody gets a retirement. But honestly, what it did is it made IRAs and 401ks and 403bs and any type of pre-tax retirement account, what it did is it made it a burden on a beneficiary. In the olden days, you used to be able to stretch it out over the lifetime of the beneficiary so that their RMDs, their required minimum distributions, wouldn't be that big. So their tax liability wouldn't be that big, right? Because remember, everything that comes out of a retirement account gets taxed as income, including when it goes to your beneficiaries. So if you're sitting here and you're caring for a loved one and they have an IRA, in the olden days, you would be able to stretch that out over your lifetime. Now, you have to cash it out in 10 years, meaning that if there is $200,000 in that IRA, $200,000 will be taxed within 10 years, depending on how you take it out. Now, that can be a lot of income tax. And what it can do, though, is it can take your income tax and pop you into a new income tax bracket. So all of a sudden, you are paying way more taxes on every penny that you have. And those are things that were unexpected. So if you have been drilled in, if you're caring for your dad and your dad has drilled it into you never to touch that IRA, You need to undo that, because that was what I was drilled into. That's what everybody was drilled into that I have ever talked to. That IRA is you save, you save, you save. I want you to know you don't save it anymore. You don't spend it recklessly, and you do it in conjunction with a tax planner, but you use it as part of your planning. So that's something I just want everyone to know. Those are the options and the things that we're going to do. So number one, talk about what's the plan. Try to make the plan before your loved one loses capacity. If it's too late, then we can get court orders. But you can also just get creative with what you have based on converting assets and spending things down. Now, one of the really big concerns that I have with the new Medi-Cal changes is, and this is why I want to publicize it as much as possible. It's not that I want to help people get qualified. It's more that I want to protect people. And because more people than ever are now qualified for Medi-Cal and don't even know it, right? So regardless of your income, you're qualified for skilled nursing. So you just have a share of cost. And what that means, right? Let's say I have $800,000 in the bank. I have a home, I have retirement accounts, and I have income of $5,000. I'm still qualified for Medi-Cal in a skilled nursing facility, but my share of cost will just be my income, right? So there's something called estate recovery. And so, I mean, I asked, the question, I raised my hand in the thing and I said, how are we going to pay for all this? And the answer back was estate recovery. We're going to get it back from people when they pass away. Is it okay? But not everybody wanted it. They just were qualified for it and transferred on to it. And they didn't know. So this is where, if you take anything from this, I want you to take that estate recovery is something that you need to consider. Now, there's old rules and there's new rules. And the only reason I have old law in here is because this is what people think of when they think of estate recovery. And so if you died before January 1st, 2017, the state of California could take back from your estate everything that Medi-Cal paid for you. And that is just everything. So if you had a house, you have a bank account, you had whatever you had, anything that you had when you died could be applicable for estate recovery. That law changed January 1st of 2017. And the new law means that the state of California can only take back from you when you die what they paid, but they can only take it back from your probate estate. That became a new big thing. Now, everybody wants to avoid probate. Most people don't know why. You want to avoid probate because it's time consuming. You want to avoid probate because it's expensive. And you want to avoid probate now because Medi-Cal can recover from your estate. And in the olden days, December 31st of 2023, people that had assets didn't think twice about it because they didn't qualify for Medi-Cal. But now that people with assets do qualify for Medi-Cal, and it's just based on the income and your share of cost, we need to avoid probate even more, right? Probate is, as I make the joke, a probate is a windfall for a lawyer, so don't pay us any more money we don't need. We need to do some planning. And you can do planning until you can't do planning, right? You can do a lot of things until you can't do them. So this is not something, I know we want to stick our heads in the sand. If I don't do it, I won't die. And nobody wants to talk about their death. I get all of this, but now it's more important than you ever could imagine. So the estate recovery under today's law, I can only recover from your probate estate. If you have a surviving spouse or a partner, legal, right, registered partner, registered domestic partner, or a surviving spouse, they can't collect, but they have to be living. So if your spouse dies before you do, everything's now recoverable. But I do want to give you this. One of the biggest things that Medi-Cal has to do if they're going to recover from you is provide you the expenses that they're subject to recovery. I can tell you that I won an appeal and took $400,000, it's like $420-something thousand off of a Medi-Cal bill because they billed inappropriately. So you want to look at the bill always and then have somebody, if you can't read it, have somebody, but they're pretty simple. You can tell. Because I knew that she was getting double billed because she was getting billed for one thing here and one thing there. And I said, she can't be at two places at once. She was either at home or a facility, and I know she was at home. So what does that mean? Assets that they cannot recover from, a revocable living trust. I cannot tell you how many people come into my office and say, I don't need a trust. I'm not rich enough. And I am going to tell you, rich people don't need trust. They've got fancy like LLCs and family, corporations and all sorts of stuff. They generally don't have that many trusts. Revocable living trusts need to be done by the average Joe. If you own a home, if you have any type of now investment accounts, things like that, you need a trust. Just having a home alone is enough for a trust. So if you own a home, it needs to be in the trust. If it's not, Medi-Cal can recover from it. Anything that's in joint tenancy will not be recoverable, meaning that if I'm on the account with mom, they won't recover from it. But if I get hit by the bus first, now they can recover from it, right? There's also a payable on death and transfer on death, POD, TOD, depending on the type of account, that's what the names are, but they both means that somebody gets it when I die. And so your bank or your investment company, they can put payable on death or transfer on death beneficiaries. Life insurance and other retirement accounts, never name the estate, right? You never name your estate. You name a person or you name your trust, but you never name your estate because then it's not recoverable. And then obviously anything transferred prior to death. There is an exception, and I want everybody to hear this, that if your home of modest value, and that's a home of a fair market value of 50% of the average price of homes in the county in which you reside. And I was just at a class in September on this actually, and they said that San Diego just hit the highest median price, and I can't remember what it was, but it was over $1 million. So it's over $1 million, and your home is worth $495,000. You now cannot be recovered against. So these are I want you to have the tools to do it. There's also, they can't recover from everything. And that's why looking at the bill is important. And so subject to recovery is, you have to be 55 or older when you receive the Medi-Cal. It has to be in a skilled nursing. It has to be, and then there's also home and community-based services. So that's the assisted living waiver, IHSS, or any person who's been deemed permanently institutionalized. I had a client who went from a hospital to an acute recovery and then went home, but she was never taken off of the permanently institutionalized code. And so then everything was done. And so everything was billed at that and then tried to recover. So you need to make sure that if you are, that you do those kind of things. Just know that if you didn't do any of this, there are hardship waivers. We have been very successful in getting them. Obviously, there has to be a real hardship, but they have a lot, Medi-Cal is not your enemy. I actually have only met one Medi-Cal worker that I didn't like, and I got apologized profusely for her, and she doesn't work there anymore because they really are good people and they want to help you. So don't be afraid to ask for help. You don't have to always have an attorney. You can just say, help me. And a lot of them want to. And then I've had a lot of people talk about first party special needs trust. If you have one, you know what I'm talking about. If you don't, you can ignore this and, talk to your neighbor. But the new rules for recovery do not apply to the payback requirements for those first party special needs trusts. So don't think there's any change to that. I just feel like it's important that I mention it. So I kind of gave a lot at you. And I wanted to leave some time for, Martha and I to kind of talk about it because I'm wondering if she has some questions or if maybe some examples of some of this might be kind of beneficial because, this is a lot. And what you're going to be going through with caring for somebody, you want to see, how can I use Medi-Cal to improve my life and my loved one's life? That's what it's for. That's what these programs are for. It's why we support them. And, we want to support the caregivers. Medi-Cal, remember, California, it is our public policy to keep people out of institutions. So we want to support the caregiver. We want to support the being at home. And so that's what these are for. So
Kim, this has educational. I took so many notes. I thought I was going to run out of paper. I really appreciate all of this information. And I just want to, to our family caregivers who are listening, it is daunting. It is very overwhelming, I think, to even wrap your head around. We're so fortunate that Kim is part of our board of directors, and she is part of that list that we provide caregivers when they're looking for attorneys or have these type of questions. As you were talking, I was just thinking that a lot of us who are caregivers and a lot of us who are in that sandwich generation who are also have children, when we are getting ready to have children, we're planning the nursery and the transportation, the babysitting and the school, and we do all this planning, but we don't really think about the planning as it pertains to us later, down the road, and also as it pertains to us as caregivers. So I wanted to ask you, Kim, kind of first question. Where do we begin? What is the first step? We just listened to this wonderful presentation. What are our marching orders, Kim?
the marching orders are from the lawyer: get an estate plan. And the estate plan can be as broad, as big as getting a trust, a will, powers of attorney, or at least get powers of attorneys, right? You need to be able to protect yourself. Who is going to talk for you when you can't? Who is going to manage your money when you can't? Who is going to talk to your doctor when you can't? Those are the important things. And then if I don't want to do this planning because I don't think I need it, and I'm never going to get sick. I'm going to have a heart attack in the middle of the night, right? That's what I hope everybody has. But, what is the plan? Think about the plan and talk to the people who are going to implement the plan. I know what I want because I've seen what I don't want. And if you don't put a plan together, you're going to get what you don't want, whether you like it or not. And so the first step should be making sure you have powers of attorney for healthcare and for assets. And ideally, if you own a home, you need a trust. And there's no exception anymore. Before January 1st, I was like, well, if you want to go to probate, fine, pay a lawyer more money. It's not the end of the world. But now, if you want your kids to get that house, you need a trust, because I don't know who's going to be on Medi-Cal and who's not at the end of their lifetime, because almost all of us are qualified for it now. And that is that's a big deal.
Absolutely. Absolutely. It's really important. And like you said, talking to those who are going to help you implement it is so important. So you don't have those battles of, that's not what mom would have wanted. Well, that's what she said, and we are executing those wishes. Step number 2, Kim, and I think, I think I speak for a lot of caregivers when we're trying to figure out what to look for in an attorney, what to look for in the individuals who are going to become part of our team, the CPA, the elder law attorneys. What do we look for?
My favorite question, because I love to say we are just service providers, right? I am not everyone's cup of tea. So you need to look for somebody that you trust and can get along with, because you're going to call them in a crisis. And you want to make sure that you trust that person and that you speak the same language. But the biggest red flag I have, and this have across the board, whether it's your doctor, lawyer, architect, CPA, financial planner, if you ask them a question and they get defensive, or if you ask them a question and they talk around the answer, run away as fast as you can. A good professional, whether it be a doctor, lawyer, architect, engineer, I don't care who they are, and they don't know the answer, will say, I don't know, but I'll find out. That is the trigger, because we don't know everything, and we're not going to know everything. So the idea is that if you get somebody who gets defensive, if you ask a question or if you question them, if you're questioning, I don't get it, I explain it better, and they get defensive, just run away. All these professionals, we're all a dime a dozen. You can find somebody. And that is probably my greatest advice, is somebody who gets defensive or unwilling to work with other people on your team, because they're afraid someone's going to know they're not good at it. And I just see that across the board.
So now I know that for our clients, we provide a service where we are able to offer through the attorneys that we work with a free consultation. Um, but let's say putting that aside, what is, and this will be my last question, what is the amount that a family should plan on spending, maybe a range to get this kind of service provided so they can establish their trust in their wills and all of this?
That is a good question now, because we've had so much change in inflation right now, right? And it used to be between two, depending on where you live, because if you're on the coast, it's more expensive. So everything's more expensive on the coast. You usually can range between 2,000 and 4,000 for just your basics, right? Just the basics. Powers of attorney can be $250. And even less if you just want the statutory, because you can go to places like Office Depot. The problem I have with that is now you don't have the transfer option. So I would recommend investing in that power of attorney with somebody who gives you a more robust one. But trusts and estate plans usually do range from the 2,000 to the I've seen upwards of 5,000. I mean, there are $15,000 people, but the average population doesn't need that. And if you're being quoted that, you need to find out why, because the average person doesn't need something. We just need a probate avoidance device, right? We need the basic trust. I get leery of the 499 guys, and I don't mean that. They have a form that they fill in that's sometimes not unique to the people. Doesn't mean, I mean, something's better than nothing. Make sure that house gets in the trust. So that's what you're looking for. You're making sure that the house is funded. That's your buzzword. Make sure your house is funded, which just means signing a deed and putting in your trust. So just make sure that the attorney and the professionals do the whole job, not just part of it.
Kim, again, thank you so much for your time. Thank you so much for your expertise and for really asking these really difficult questions that I think sometimes caregivers don't even know about. You know, you don't know what you don't know. I used to have a mentor who would always say that. So if I don't know what to ask, how am I going to ask it? But also as we plan, not only for the person that we're caregiving for, but for ourselves. Since we are going to be aging, since we might be in that situation, so I like to put your contact info once again on the screen in case people want to contact you if they have additional questions. I think this would be a really good place to start. And of course, doing your research, doing your homework, gathering all of these documents, but more than anything, having these conversations with those around you, with the people that are going to be impacted, and really with yourself as well, just kind of sitting down and figuring out what is it that I want as I go through this process. Thank you so much, Kim. We really appreciate you being here, and we are so fortunate to have, like I said, your support and to be part of our board of directors. And again, stay tuned for another live stream. We do these every month. Feel free to give us a call at 858-268-4432 or visit our website where you see all of these wonderful videos, a lot of our services that we provide to the community by visiting caregivercenter.org. All right, thank you and see you soon.